Symposium on Encounter Killings in India and the release of this excellent report on encounter killings in UP and and how they kind of sort of came out. And on behalf of the Center for Criminal Justice Reform and Research, I welcome you all today here. The center is quite recently established, in fact, just in 2020, in fact, just when the pandemic set in. And we're trying to set it up as a platform where policymakers, judges, all those who have a stake in the criminal justice system can have an interaction, and we can actually think of, though it's a very daunting, and challenging task, to think of trying to push towards some kind of policy reforms. And today we are going to be talking on encounter killings in India, which is a subject which is always relevant in India, given the fact that killings are routinized, endemic, and hardly ever punished. And so we have with us Justice Madan Lokur, Dr. Yugbhoy Chaudhary, and also Justice Raghuram, who will be joining us through his recording today. But just to kind of briefly lay out, as I said, it's been, this report is about Uttar Pradesh, but really it's nothing novel about Uttar Pradesh. We've had across states, across different governments in power, we've seen encounter killings and policies of encounter killings, whether it was in the name of combating Naxalites in Andhra Pradesh in the 1970s, or from 1970s onwards, or whether it's combating insurgency in Punjab or insurgency in Kashmir, or now in UP, of course, you have it as a stated policy of crime control. In fact, it's the flagship program of crime control in Uttar Pradesh today. But as things go back quite a bit, in 1977, in fact, as early as 1977, the Tarkunde Committee was set up by the Janta government, by Jay Prakash Narayan, in fact, who asked to the committee headed by Tarkunde, Justice Tarkunde, to look into almost 77 killings that had taken place only in the state of Andhra Pradesh, although there were reports of encounter killings in Odisha and many other states as well. And this is a report that is available on EPW if anybody is interested. It's called Encounters Are Murders, and one will find that when you read that report, you feel like crying. That it's almost like the modus operandi of the ways in which the state agencies kill and work, and the ways in which the whole mechanism of attaining or rather thwarting justice is put in place. Nothing has changed, really. Nothing has changed. And in fact, they were put in place very early in the life of our republic. Now, if the ways in which agencies collude, agencies which we think are tasked with the job of protecting human rights, the ways in which they collude to ensure that justice is never delivered, whether it is the courts, whether it is the magistrates who are supposed to do inquiries, whether it is the highest, bureaucracy of the police system itself, and whether it is the NHRC, which is supposed to be the custodian of our human rights. The ways in which all agencies collude and ensure that justice is thwarted has been there from the start. It's not new, of course, right? And it also, if you read Encounters Are Murders, you will find that, the whole routinization and normalization of encounter killings set in quite early in our republic, right? And you had, of course, APCLC has done some excellent documentation around encounter killings in Andhra, where, through its reports, it showed how in the 1980s, in fact, police officers who had killed, so-called Naxalites were being given cash awards and publicly felicitated by political leaders, by home ministers and so on, right? Now, in Khalistan, in Punjab, when the Khalistan movement was at its peak, you had the bounty system formalized by KPS Gill. I remember in 2013, there was this kind of an expose, or rather a former sub-inspector of the Punjab police who came forward and in a press conference said that he had killed 83 Sikh men who were passed off as militants, as Khalistani militants. And he said that he did so at the instigation of his seniors. And he said, I was promoted, and why was that? So we have built-in incentives to kill people. And, elsewhere, we've seen how encounter killings are used as a mechanism to kind of burnish leader's image, Hriday Samrat of a particular community, to sort of establish yourself as, a leader or a kind of a flag bearer of very hardened majoritarianism, and which is what I think Yogi is trying to replicate in UP as well. But I don't want to kind of give a catalog of encounter killings we've seen as we sit in, I'm in Hyderabad, and so as we speak, there is a commission of inquiry sitting in, which is inquiring into the killing of the rape accused in a rape case which happened 2 years ago, the Disha encounter case. So I don't want to provide a catalog, but just want to point to two things before I invite Mangla to really present. The first is that after 7 decades of independence, we are still struggling with this minimum that when police kills somebody in action, that they be required to prove that they fired or killed in self-defense. I mean, this is the minimum. Article 21 should have been, an automatic sort of guarantor for that. But we're still struggling and almostly failing to ensure that this minimum is ensured. And the second is that whenever we see any encounter killing, what follows automatically, spontaneously, is a narrative of guilt is built around the one who's been killed. Right? It's almost as if death furnishes the proof of one's guilt almost, So you find that people who are killed, they are the ones against whom FIRs have been filed. And because they are dead now and the dead don't speak, we know, they are almost declared, terrorists, extremists, insurgents, whatever have you, and whatever is the flavor of the month really at that time. So, and another, interesting point that we see in India is that this distinction between fake and genuine encounters is often built on certain categories. So if a person who's killed belongs to what I call the encounterable category, you could belong to a specific caste, specific religion, specific political ideology, or you could be shown through association to belong to these groups, then somehow that encounter is genuine, or is deemed to be genuine, both by those who should know better, but also by the public. So I just wanted to make these couple of points, and I am very proud to invite Mangla to present the report. And I think she's really, Mangla and her team is really, the heir to the legacy of APCLC and the kind of work that Justice Khalra did, who calculated the number of dead in Punjab on the basis of the kind of the amount of firewood that was being used by crematoria. So I think this is a remarkably brave report. Writing about these things in these times takes a lot of courage, and I'm so glad that this report has been written, and I recommend everybody to read it. We shall be posting the link very soon on the chat box. So I now call upon Mangla to present the report, the main findings of the report and how they went and did it, and so on. Thank you, Mangla. Go ahead, please.
Thank you, Manisha, for that introduction. It's a very tall standard to stand up to, what you just said. We are extremely grateful to Nalsar and to you, Manisha, for organizing this symposium and for giving us this opportunity to present our work. We're also very grateful to our esteemed panelists who have come here, taking out time to discuss this pertinent issue here today. The report is now available on our website. I'll just share my screen and I can show you. You can access the report on our website, yhrd.in. You can download the report from here. And this is just to give you a little sneak into the report. Extrajudicial killings, also known as encounter killings, are not a recent phenomena in India. The directions issued by the Supreme Court in PUCL versus State of Maharashtra in 2014, which have the binding force of law, along with the NHRC guidelines and the criminal law provisions, provide a legal framework for the investigation and trial of such killings. Uttar Pradesh has been an active theatre of encounter killings since March 2017. Media estimates suggest that there have been more than 8,400 instances of police firing as a result of which 146 men have been killed and another 3,300 have been grievously injured with bullets. This development has received scrutiny from 5 special UN rapporteurs, and multiple petitions questioning these killings are pending at the Supreme Court and the NHRC as we speak. However, the state government has always maintained that all these shootings have been carried out by the police in self-defense while making arrests, and that the investigation by different authorities have exonerated the police officials, finding no violations of law and procedure. Our report, Extinguishing Law and Life, evaluates this clean chit given to the police after investigation through an analysis of 17 cases of police killings in UP. The report examines the role of the investigating agency, which is the UP police in this case, the executive magistrates, the judicial magistrates, and the NHRC to assess the standard of investigation undertaken by them and whether this investigation complies with the legal framework existing. It is based, this report is based on the analysis of legal records such as FIRs, post-mortem reports, inquest and magisterial inquiry and closure reports, FSL and ballistic reports, MLCs, and treatment reports of injured police officers, court orders, and statements which were recorded by the NHRC of medical doctors, forensic experts, police personnel, family members, and witnesses. The report reveals gross violations of law, both procedural and substantive, by the investigating agency and the judicial magistrates while investigating these killings. Independent bodies such as the NHRC and the oversight mechanisms such as the magisterial inquiries have failed to identify these violations of law and have ignored factual contradictions in the police version of events. Instead, they have routinely condoned the unconstitutional procedures followed by the police during these investigations. The key findings of our report are as follows. Of the 17 cases which we analyzed, in not one case has an FIR been registered against the police team that was involved in the killing. Instead, in all 17 cases, FIRs have been registered against the deceased victims on charges of attempted murder. Thereafter, in majority of cases, the initial investigation into these FIRs is conducted by a police officer from the same police station as the police team which was involved in the killing. This violates all tenets of independent investigation and raises grave doubts about the preservation and fabrication of evidence. Investigation was later transferred to another police station in all of these cases, only to show compliance with the PUCL guidelines. It is not surprising then that these so-called independent investigations conducted by the UP police have reached the same conclusion in all of these cases, that the deceased were killed by the police in self-defense. The investigating officers have then filed closure reports in 16 out of the 17 cases that we analyzed. This conclusion is in violation of law that clearly states that the justification of self-defense for murder has to be proved and determined through a judicial trial. The police's defense cannot be presumed from the police version or confirmed merely through an investigation. The closure reports that we analyzed were also identical and sought closure of the cases on the ground that the accused was dead and the police could not find any information about the accomplice who escaped the crime scene. In most cases, the judicial magistrates have accepted these closure reports, even though this process has been held to be unconstitutional by the High Courts and the NHRC in other instances. The judicial magistrates have not raised any questions about the role played by the police and whether the force used by them was necessary or proportionate. They have also overlooked glaring inconsistencies and contradictions which are apparent from the legal records, such as the post-mortem reports that we analyzed clearly show that the lethal force was used by the police, as the bodies of 12 of the victims out of the 17 show multiple gunshot wounds on the torso, abdomen, and even on the head. Some dead bodies also show fractures, indicating brutal torture before death. This contradicts the police claim that minimal force was used or that the bullets were aimed at the lower part of the victims' bodies to immobilize them and ensure their arrest. Further, police only sustained minor injuries in all of these incidences. So out of the approximate 280 police personnel involved in these 17 police killings, only around 20 police officers have sustained injuries. In 15 out of 17 cases analyzed, the police sustained only minor injuries. In fact, in 7 cases, there is absolutely no proof that the deceased was even holding weapons or even fired at the police, as the fingerprints of the deceased were not found on the weapons recovered from the scene of crime. The magisterial inquiries also conducted in these cases are in violation of law. Section 176(1)(a) of the CRPC requires an inquiry into the cause of death of a person in custody by a judicial magistrate. However, in all cases, these inquiries have been conducted by an executive magistrate. The executive magistrates have held the police killings to be genuine, acting well beyond their powers and jurisdiction, which is only limited to determining the cause of death and not whether an offense has been committed. The executive magistrate's findings and reports are predominantly based on the police version, and most reports do not even consider forensic or ballistic evidences. The statements of family members have either been not recorded or recorded in a very perfunctory manner. These 17 cases were also investigated by the NHRC. 3 years after the investigation was ordered, the NHRC has now closed 12 cases, finding no foul play on the part of the police. In only one case, the NHRC held that the deceased was indeed killed in a fake encounter, but did not question the closure of the police investigation that followed immediately after the NHRC found the officers guilty of murder. Like the judicial magistrate, the NHRC, while closing these 12 cases, have also overlooked glaring factual contradictions and inconsistencies in the police narrative. It also turned a blind eye to the violations of procedural and substantive law. For instance, the registration of all FIRs against the deceased victims, and that no FIRs were registered against the police, the closure of investigation on the grounds of self-defense without any judicial scrutiny, and violations in the collection and securing of evidence from the scene of crime, to name a few. Even though the investigation went on for almost 3 years, the NHRC failed to even procure material scientific evidences, let alone any scrutiny of the police claims. Our research also shows that the burden of ensuring investigation and accountability in these cases falls entirely on the victims' families. The families have faced intimidation, threats, and murder attempts, along with persecution through false and fabricated criminal cases. The NHRC also failed in ensuring protection of the victim families and witnesses. For instance, the NHRC neither responded to nor took on record 13 letters that were submitted to them regarding the persecution of the 17 families and human rights defenders that were supporting them. In absence of substantive witness protection mechanisms, in such cases of police killings, the pursuit for justice becomes nearly impossible for the families. To conclude, this report, which is a result of a 3-year-long research conducted by civil society groups, Youth for Human Rights Documentation, People's Watch, and Citizens Against Hate, and others, lays bare the abject failure of the criminal justice system to ensure accountability for police killings. It shows how the justice system is unable to hold police officers accountable for use of force causing death. It exposes the ambiguities and gaps in the Supreme Court's guidelines in PUCL versus State of Maharashtra, which are effectively translating in practice into impunity for killings by the police. These gaps include introducing ambiguity on FIRs to be registered against the police, introducing vagueness, which allows the plea of self-defense to be misused by the police and claimed at the stage of investigation instead of trial, ambiguity regarding mandatory inquiry by a judicial magistrate, and the improbable expectation of a fair and independent investigation by the state police department into crimes by their own colleagues. However, what is most concerning is the increasing normalization and glorification of police killings as a method of crime control. which in reality is translating into permissive lawlessness. This culture of impunity is not an accident, but a manifestation of systemic failures and our collective silence or celebration of quick fix vigilante forms of justice. Thank you. Manisha, you're on mute.
Hi, thank you, Mangla. Now I invite, we shall come back to the report in due course during the discussion. Thank you very much for putting out the main key points and your key findings for all of us. Now I invite Justice Madan Lokur to share his thoughts with us. And I think he needs no introduction, but I would still like to say that, over the years that he served on the Supreme Court, the bench that he headed was known as the Social Justice Bench. And he's one of the few, we constantly expanded the, human rights jurisprudence through his orders on right to food, shelter, health, dignity, livelihood, and what have you. And it's judges like Justice Lokur who make us want to believe, despite ourselves, in the possibilities that the judicial process holds. So I'm so glad that Justice Lokur is able to join us today. And in particular, we are interested in, I'm sure he will be dealing with that issue as well. The petition that was filed in the Supreme Court by the Extrajudicial Execution Victim Families Association of Manipur, who had alleged over 1,500 encounters, and responding to which Justice Lokur and Justice Lalit, upheld the jurisprudence that use of excessive or retaliatory forces by the armed forces is not permissible, and that every single act of killing requires investigation. And that in fact led to, a SIT of the CBI and the filing of FIRs, etc. And I'm sure Justice Lokur will be speaking on that, so I will not preempt that. But thank you again, Justice Lokur, for agreeing to speak here today. So over to you, sir.
Yeah, thank you, Manisha. I'd like to begin by congratulating the really outstanding report that has been prepared by Youth for Human Rights Documentations, Citizens Against Hate, and People's Watch, and the excellent summary that Mangla, you've presented. I think it's really outstanding. One of the questions that often arises is, what is the use of a report like this? Why do we need these kind of reports? The importance of the report really is that it provides a contemporary record of what is happening. Manisha, you had mentioned about what happened in Punjab, what happened in Andhra. Now, there is some record. There is an outstanding judgment given by Justice Raghuram. There is this Justice Tarkunde committee report. But that's just about it. I know that when we were dealing with the extrajudicial killings in Manipur, there was just no record available. All that was told to us was that, this person was an insurgent trying to escape, tried to, snatch the gun, fight with the paramilitary forces, and therefore there was no option but to shoot him. But what is the reality? Was any analysis done? It's just completely missing. There were, of course, a few orders that had been passed by commissions of inquiry set up under the Commissions of Inquiry Act, and also on directions given by the High Court, the Guwahati High Court. But that's about it. So really the importance of the report is that we today have information about exactly what is happening. What has happened not many years ago, but just fairly recently, maybe a year or two ago. So we have a good detail of what is happening, and we can be prepared for these kind of events. And why I say this, work is outstanding is that these cover-up operations are really very, very good. I remember as a lawyer in the mid-1980s, we had the Tisazari courts, which was, a huge district court complex. Within that district court complex was a police station. There was, significant police presence. There were offices of the Delhi government as well. And the lawyers had been saying that, let's get the police out from here because it becomes difficult for witnesses, criminals, and so on and so forth, alleged criminals. And no steps were taken. Something happened. I don't quite remember exactly what transpired, but there was a massive clash between the police and the lawyers. Kiran Bedi at that time was in charge of the police in the Tisazari courts. An inquiry committee was set up consisting of 2 sitting judges of the Delhi High Court. And they had a really tough time trying to find out what exactly happened. And it's only when, criminal lawyers began intervening in the proceedings and they were able to tell the commission about, wireless messages and so on and so forth, that the truth came out. So really the cover up, which is what I think you have been able to expose in this report, is very important. That this is the way, these kind of instances, incidents are sought to be covered up. And this is what is required to expose the cover up operations. I think that is extremely important. The second thing that I would like to say, taking it forward, what next? We've had, as it was mentioned by you, Manisha, that we've had, encounter killings, fake encounters, and so on in Punjab, Andhra, Chhattisgarh, other places as well. I mean, Maharashtra, it's not only confined to UP, but today we are having a similar scenario in Assam, right? Where things are not so bad in Manipur as they were, maybe 10, 15 years ago or 20 years ago. But yes, you do have instances of encounter killings in Manipur as well. But in Assam, yes. Kashmir, difficult to find out what's going on. You can make an effort. I don't think you'll reach anywhere. But like you've been able to do for UP, I think a similar study, if it is carried out for Assam, will give you, a comparative analysis of how these things happen. We have a template in UP, which has come out very well in the report, that a person was trying to escape, he tried to snatch the gun, and so he was shot. Is it the same template that is being used in Assam, or is it a different template? How are the police going about it? So we get an idea of where our justice system is failing. What exactly is the police doing? How are they doing it? And how can we prevent all this from happening? So I think as a step going forward, it would be a good idea if a study could be done of Assam, and hopefully there are no more encounter killings in any other states. But if there are, there's one in Hyderabad, we get an idea of what exactly is happening. I'm looking at the future. What are the lessons that we have learned from this report? I think we've learned a lot of, lessons. There are a lot of ideas and thoughts which are ingrained in our system, which we need to look at. One is the template that is being used. Standard template all across these 17 cases that you have studied. We've also learned how difficult it is for the family of the deceased to get justice. It's virtually like the killing is the start of the problems. It's not the end of the problem so far as the society is concerned, or so far as the deceased is concerned. It's the start of the problem for the family. and telling them that, listen, we're going to give you money. Take 10 lakhs and be happy. Take 5 lakhs, be happy. That's not a solution. I mean, there's much more to life than, 5 lakhs or 10 lakhs. The family has to go through tremendous trauma. How are they going to survive? What about justice? They believe, and they may be right in saying that this person was completely innocent. I mean, he was not even a criminal, or maybe petty criminal, petty thief or something. But does it mean that you take the life of this person? What about justice? So these are issues that we have to tackle. That how do we give justice to these people? First of all, of course, why should this happen at all? And if it does, how do we provide justice to these people? Money, according to me, is not the answer. What about accountability? Is the police accountable? Now, we've had 1,500 killings in Manipur. Nobody, to the best of my knowledge, has been convicted. And what is it? I mean, the family is just supposed to go through life knowing that somebody is being killed. There was a request made, a committee set up, chaired by Justice Hegde. The Supreme Court had requested him to look into 8 instances. He looked into 8 instances. He found that one was the police may have been, or the paramilitary forces may have been justified in the action that they took. But the defense was standard, self-defense. Out of those 8 cases, in 7 cases, Justice Hegde found absolutely no justification for the action that was taken. One of those cases was of a boy who was 12 years of age. And according to the paramilitary forces, he was an insurgent trying to run away, so they shot him. Now, can you imagine under the IPC, first of all, a 12-year-old child, you have to try and figure out whether he knows what he's doing. And only then you can proceed against him. But here, declared as an insurgent and shot dead. So, and these people are living with it. What are they supposed to do? No investigations took place. The Supreme Court directed the CBI to look into the matter. What has happened? Nobody knows. The lawyer, that's what the newspapers say, mentioned the matter 3 times before the Supreme Court. Please take up the case so that we know what the CBI is doing. No, the case has not been taken up. It's been almost 3 years. Nothing has happened. What happens to the family? Can you say, all right, we will give you 3 lakhs, we'll give you 5 lakhs, be happy? Forget about who killed who. That's not an answer. So accountability is very, very important. Otherwise, you have issues of impunity, Armed Forces Special Powers Act. You can do whatever you like, and that's it. No questions asked. It can't be like that. We are living in a society governed by the rule of law. It can't be like that. The rule of law doesn't permit, wanton killings. Witness protection, very, very important. It's not only very important in terms of encounter killings, but also regular crimes that are committed. Witnesses have been attacked. Witnesses have been killed. You've had lawyers being beaten up. You've had lawyers being threatened. I mean, what's going on? Now, this is in, a murder case or maybe a rape case. But in an encounter, a police encounter, the accused is, in that sense, the police. So if an ordinary citizen can, traumatize a witness or kill a witness or injure a witness or injure the lawyer, well, the police machinery is much stronger. So what do we do about witness protection? And then, witnesses turn hostile and we say, oh, they've turned hostile. What is to be done? We can't compel them not to turn hostile. So why did they turn hostile in the first place? So these are things, which you have brought out in the report and which are very important. Manipur, again, I'm sorry, I just keep bringing it up. These people said, we are willing to come forward and give evidence, but who is going to take evidence? Nobody. Why? Because the state says we're not interested. The CBI, I don't know what they're doing. In some few cases, where inquiries were held, people were found guilty. That's it. What happens after that? The trial will take its own time and people will get away with it. They'll get transferred out. How are you going to catch them? Where are we failing? What are the disappointments? I would say, speaking generally about the criminal justice system, I think the judiciary has been a bit of a disappointment. In Manipur, like I said, we don't know what's going on, in spite of orders passed by the Supreme Court. You will be surprised. I checked up this morning. There are 28 lakh cases that are pending where the accused is absconding. 28 lakh cases. And if each case has only one accused person, you have 28 lakh people who are absconding. What is the justice delivery system doing about it? You have 2 lakh bail applications pending. We've been talking about bail to Aryan Khan. Good, he's got bail. There are 2 lakh other such cases pending. You have 22 lakh witnesses who have not appeared in court. Cases are being adjourned because witnesses are not appearing. And how many of them are there? 22 lakh. What is the judiciary doing about all this? Encounter killings is the last stage. There is one more stage after that where the person goes missing completely. But if there were 5 stages, according to me, encounter killings are the 4th stage. The victim going missing is the 5th and final stage. We're talking about the 4th stage. And this is the kind of justice that is being perhaps delivered. National Human Rights Commission, you've said in your report quite clearly, doing nothing. Absolutely nothing. 3 years they've been sitting on it. State human rights commissions, nobody even talks about them. What is the use of having bodies like this? If nothing is going to happen, might as well abolish them. You've abolished tribunals, might as well abolish NHRC and state human rights commissions. If they're going to do nothing, well, why should the taxpayer pay for them? Police accountability commissions, ordered way back by the Supreme Court in Prakash Singh's judgment, non-functional. Perhaps not existing in many states, but where they're existing, not functioning. Civil society, unable to do anything because of, what's going on. That's where, reports like this become important, because yours is a civil society contribution. That is what is important. Where the civil society says, all right, if you guys are doing nothing, we're not going to sit back. We're going to come out with the facts. If they're uncomfortable to you, too bad. But we're going to do our work. And that's why I believe that your work is very courageous, because you have fought the odds, which are there for all of us to see, and you've succeeded. 17 is a good enough number. I think you had mentioned that there's something like 146 deaths. Right, so 17 is definitely more than 10%. But is somebody ever going to look into the balance? 130 or whatever, 129 cases? And if not, why not? So, it's courageous, it's important, but we shouldn't stop here. We have to go forward for the sake of our society. So I would congratulate all of you for this excellent work, and keep on at it. I'm sure you have the support of everybody. All the best.
Thank you very much, sir. Thank you for sharing your thoughts with us. And since you mentioned Prakash Singh, I'm tempted to say that, remind everybody that when the UP encounter killings began, and because Prakash Singh is seen as somebody who's like the poster boy of police reforms, he wrote an article in the Indian Express saying that, these are not enough numbers of killings to start worrying about. And that how in previous governments, there are certain sections who had been allowed to run amok. And so therefore, this was only restoration of law and order. So I think we also need to pay a little bit of attention to when we are talking about police reforms, to think about, the question of accountability, as you were saying, and to keep that at the center of our understanding of police reforms, rather than just simply, the disjunction between, or freedom from political, influence and so on, which is usually touted as, the path to police reforms. So, but thank you very much, sir. Now we have Justice Raghuram, who's not here today with us because he's flying to a meeting, but he was gracious enough to record his thoughts for us. And Mangla will share that video with us in a minute. And Justice Goda Raghuram was at the Andhra Pradesh High Court, former judge of the Andhra Pradesh High Court, and he recently retired as the director of National Judicial Academy, Bhopal. And in fact, he's the author of the, the 2009 judgment, which is famously known as the APCLC judgment, wherein, it's a kind of masterly meditation on what rule of law means, and why there should be an investigation into every killing that the police engages in. So, and I really, for me, it's like the, the gold standard of judicial rulings on encounter killings, against which every, court ruling must be sort of weighed. And unfortunately, very few rulings, come to par with that judgment. It was obviously, it was impromptu stayed by the Supreme Court. And this happened in 2009, and, just after the Bombay carnage in November 2009. So where the AP Officers Association, Police Officers Association was able to influence the Supreme Court to, by saying that, this is, how do you expect us to investigate every police killing if, we are confronted by these so-called terrorists who will come from the sea. But we know, as this report shows, that not everybody is coming by sea, those who are being killed. And so I request Mangla now to share Justice Raghuram's video with us. Thank you. And just an announcement, that all of you who might have questions, concerns, comments to make, you may please type in the Q&A box, which you will be able to see on your screen.
I'm delighted to be at least able to contribute a couple of minutes of my thoughts on police encounters. I was very eager to be digitally present at the symposium, and I readily agreed when Madam Manisha asked me, but that was not to be. And I had official preoccupation. I was traveling at that exact time on 29, and therefore I just wanted to share my thoughts in this area. On the process to be followed in case of a police encounter, the larger bench judgment of the Andhra Pradesh High Court in its 2009 APCLC judgment, it's called generally, issued certain 4 directions. There were about 5 or 6 directions, but critical are 3. I was a part of that bench, and after detailed argument, the bench had given some directions. The first is that when a police officer causes the death of a person acting or purporting to act in discharge of his official duties or in self-defense, as the case may be. The first information report relating to such circumstance, even when such report is by a police or a public official, whether the alleged perpetrator is named or otherwise, shall be recorded and registered as FIR, First Information Report, enumerating the relevant provisions of law under Section 154 of the Code of Criminal Procedure of India, and shall be investigated under Section 156 or 157 as case may be. That was one core direction. And the second direction is that the existence of circumstances bringing a case within any of the general exceptions in the Indian Penal Code, including the exercise of the right of private defense, a general exception in Chapter 4 of the IPC, cannot be conclusively determined during investigation. The opinion recorded by the investigation officer in the final report shall be forwarded to the magistrate under Section 173. Such opinion contained in the report is a mere opinion. That opinion contained in the final report shall be considered by the magistrate in the context of the record of investigation, together with the material and evidence collected during the course of investigation. And core part of this directive is that the magistrate to whom the final report is submitted, notwithstanding the opinion of the investigation officer, which could be to the effect that no cognizable offense appears to have been committed, or that one or more or all of the accused are not culpable, or that the investigation discloses that the death of civilians in a police encounter is not culpable in view of a legitimate exercise by the police forces of the right of private defense, the magistrate shall nevertheless critically examine the entirety of the evidence collected during the investigation to ascertain whether the opinion of the investigation officer is borne out by the report of investigation. The magistrate has the discretion to disregard the opinion and take cognizance of the offense in relation to the relevant provisions of law, the APC, under Section 190 CRPC. And the third critical directive in APCLC is that a magisterial inquiry or what is called an inquest under Sections 174 to 176 CRPC is neither a substitute nor an alternative to the obligation to record the information as FIR and conduct investigation into the facts and circumstances of the case, and to take measures for the discovery and arrest of the offender under Sections 154, 156, and 157 CRPC. These, in my view, are the heart and crux of the directions of the larger bench. The principles on which the APCLC judgment is predicated are about 4 or 5. And the first one is that on principle and theory, there's a distinction between war and peacetime law enforcement, while victory, which has rarely any moral connotations, barring the few like the Vienna Convention on the treatment of prisoners and such like, is the object of the first category of use of force. While bringing to justice the perpetrators of offenders, against the law, which has clear moral connotations and is circumscribed by clear values, principle and statutory constructs, is the object of the second category of use of force, that is, for peacetime law enforcement strategies. The second principle on which the APCLC is based is that executive and judicial sanctions against life and liberty must be explicitly spelled out in legislative authority and may be administered only in terms of the substantive parameters and in accordance with the legislative due process, never ever otherwise. The third is that the balance, this is the distillate from historical narratives, that the balance between liberty and authority is delicate but clear. The balance must be maintained at all costs and all times and in all circumstances. Else, the equilibrium of the society is disturbed and the painful circle from anarchy to tyranny will recur incessantly and society will decay into barbarism. The fourth principle is that the only defense invariably asserted in all cases of police encounters is self-defense. This general exception to criminal culpability in Chapter 4 of the Indian Penal Code is available not merely to the police force, but equally and with equal regard and amplitude to private persons, subject of force to the satisfaction of the parameters justifying the specific defense needed. This is true of all Chapter 4 defenses. Applying the defense on the mere assertion of the police force would undermine the rule of law and the provisions of the Constitution and the other laws. The fifth principle, core principle on which the APCLC judgment rests is that if randomly and irrationally employed, the private defense general exception to criminal culpability, which is carefully conceived in the larger interest of social harmony and equilibrium in the IPC, regenerates the benign purposes of immunity from criminality into criminality with impunity and threatens the rule of law. This judgment was considered in appeal for the Supreme Court, and in the judgment of July 2019, the Supreme Court disposed of the appeals. The court directed that since the directions in the AP judgment are fully covered by its own earlier judgment, UCL versus State of Maharashtra and others, it's a 2014 judgment, and in particular the directions spelled out in paragraph 31 of the Maharashtra judgment. Those directions be treated as law under Article 141 of the Constitution, and these shall hold the field. That is, the directions in paragraph 31 of 2014 UCL versus Maharashtra and other judgment. Therefore, in my view, the directions set out in paragraph 31 of the 2014 judgment of the Supreme Court in UCL versus Maharashtra govern the field today. To this extent, there is, to my comprehension, a scaling down of the amplitude of the directions in the APCLC decision. That is the position of the declared law currently. I am of the view that the second and third directions in the which I alluded to earlier in the APCLC judgment are whittled down by the 2019 judgment of the Supreme Court. But that is a law declared and operated.
We'll have to stop here. The audio after this is a little not understandable.
Thank you, Mangla. I'm sorry we had to stop there. The audio wasn't that great. Now we have the last speaker for the evening, Dr. Yugmoy Chaudhary, who practices in the Bombay High Court and is one of the leading voices against the death penalty in India. But he's also represented, amongst others, the victims of the Sarkeguda encounter in the one-man Justice Agrawal Commission, and he's had some experience of representing other family members of those who've been killed by the police. So I invite Dr. Yugmoy Chaudhary now to share his own experience of fighting against this whole stacked up system, where we see all the agencies kind of coming together to ensure that justice is not delivered. Dr. Chaudhary, please.
Thank you, Manisha. In my experience, the history of any efforts to obtain substantial justice for the victims, the family members of these encounters, and I don't mean monetary justice, I mean substantial justice of the kind that Justice Lokur just spoke about, has been a history of abject failure. I myself have failed on a large number of such cases which should never have failed, but they failed at the first hurdle. Even though there was plenty of evidence at the time of filing of charge sheet in some of these cases, the courts discharged the accused. This has happened repeatedly. In most cases, even charge sheets are not filed, even FIRs are not registered. And hence the importance of Mangla's report, because it bears witness. The only way we can actually compensate for the failure in the court is to actually still stand up and say, I have a voice, to bear witness to what has happened. And Mangla does that eloquently. I would like to talk about the reasons. I've been also part of one or two cases which have succeeded in some small measure, not even all the way, but in some small measure. And if I think of the differences between the cases that failed, which are many, and the cases that succeeded, which are so few, and I say succeeded in very small measure, what stands out is really two things. One, control over the narrative, and two, obtaining of information. In any encounter, the first narrative that is put out is that by the state, by the police, the security forces. And having done that, they control the narrative for a long time to come. This control of narrative not only influences media and popular perception, it influences judicial responses to what has actually happened, any attempts made by the family members to obtain justice. This control of narrative is crucial for the state. If we have to succeed, we have to wrest control over the narrative. We have to wrest it back. We have to gain control over the narrative. Now, let me give you an example of a couple of cases where this happened. Where did this happen? And these are the two cases that come to mind where there was a small measure of success. One of the last encounters that occurred, in fact, the last encounter that occurred in Bombay, which is the city of encounters, was the encounter of Lakhan Bhaiya. And the reason it was the last encounter is because the perpetrators of that encounter were actually put behind bars due to the efforts of Lakhan's brother, who was a lawyer, Ram Prasad Gupta. Now, what happened in this case was that Lakhan Bhaiya was abducted by a team of encounter specialists, taken away, and then shown to have been killed the next day in an encounter. But unknown to the team, as soon as he was abducted, his brother dashed off telegrams to all the high dignitaries, constitutional and executive, that he could possibly think of, and documented this abduction. In the face of this very detailed and prior documentation of the abduction, the police failed to wrest control of the narrative. Nobody accepted the police narrative, not even friendly media. Thereafter, Lakhan brother filed a writ petition, got an SIT appointed, got these people prosecuted. All but one were convicted and sentenced to imprisonment. Now, I want to give you one follow-up on that, just to show you the nature of the state, to understand what we are up against. There is a they were convicted. The police officers were convicted under Section 302 IPC and sentenced to life imprisonment. There is a provision in the CRPC, Section 433A, which says that anybody convicted of an offense punishable with death or life shall not be released unless he has spent at least 14 years in custody. Within 6 months of the conviction being recorded by the trial court, the state government proceeded to grant premature release and suspended the sentences of these convicted police officers, even though bail had been refused by the High Court, both under trial and post-conviction. In spite of that, the state government went ahead and, exercising powers that it had under CRPC, it suspended their sentence and had them released. Well, Bombay High Court showed some spine and said, no, we will have none of it, and sent these police officers back to jail, where they are still till today. And now the appeals are being filed. So we have had a conviction in this case. The reason I say it's not a complete success is because the mastermind, the number one person behind the killing, the person who actually fired the fatal bullet which killed Lakhan, was acquitted by the trial court, even though the ballistics matched with his gun. I mean, if you have that kind of evidence, one wonders, how do you get an acquittal? There was a clear ballistic match, and still he was acquitted. So you have to understand, even after they were convicted, the state did everything it could to ensure that they were not punished. And you have to understand why the state does this. The state needs these encounter specialists to do their bidding. And therefore, they must thereafter protect these encounter specialists with in whatever way they can. We have to understand who we are up against. We are not up against some kind of anonymous, neutral, benign force. The state is wholly complicit in encounter killings, in torture. It believes these are valid forms of killings. These are necessary and they're justified. Let me give you another example where there has been a small measure of success. And again, due to not so much the control over the narrative, but by setting up of a counter narrative and by obtaining information. And this is the case of 17 tribals who were shot dead by the CRPF and called Naxalites in Sarkegoda. This case was initially taken up, a great deal was made of the killings, and the Congress government at that time ordered a commission of inquiry. Now that was a huge move forward, which is very rarely done. And civil society, particularly JAGLAG, they seized this opportunity and produced evidence of witnesses from that village to show that the firing was wholly unprovoked. There were no Naxalites there. There was a meeting going on of the villagers to discuss what should be done for the Beach Panjum festival, which was coming up. And there was no firing from the villagers' side. Now, these affidavits, and they were completely demolished in cross-examination by the state's lawyers. So effectively, there was no evidence produced on behalf of the villagers. And to be quite honest with you, it was fair to reject those affidavits because the cross-examination was good. The witnesses, being rustic tribals, they couldn't stand up to cross-examination. Then came the turn of the state, the CRPF and the police to lead evidence. And it is here that we scored a major victory, because by that time, the state had, of course, as they always do, filed charge sheets under 307 in the trial court against the dead and some of the injured and some of the other villagers. In those charge sheets was vital information pertaining to issuing of rounds of ammunition. And the numbers of people in the two police parties, various other information, vital information. It was a gold mine. We used that information and cross-examined the CRPF. They broke down in cross-examination, one by one, all of them. The story put out by the CRPF of their injuries was so farcical. Let me give you a few examples. The officer steps into the box and claims that he suffered a bullet injury on his cheek, and the medical certificate records a bullet injury on the elbow. Another one says he suffered a bullet injury on the head. The medical certificate records a bullet injury on the toe. Things like that. During this process, they put up as much resistance as they possibly could to prevent us from cross-examining. So every time I flew in from Bombay, they would make sure none of the witnesses appeared. And they did this around 6 times. They ensured that, even if the witness was brought there, he would be taken back. And the judge would be told, the commissioner of inquiry, the judge, that the witness couldn't come, it was raining, or he's got a medical emergency or something or the other. They made it as difficult as possible. Then, in open court, the state lawyers accused the JAGLAG lawyers, they accused me, and they accused a journalist, one solitary journalist who was following this inquiry, of being Naxalites. And repeatedly, we were called Naxalites in open court. Not once, a dozen times. In front of a judge, and questions were asked, why is this lawyer coming from Bombay? Is there someone who can pay his fees? Who is paying his fees? What is his commitment to this? Why is he so committed to this? These are all Naxalites. They fired on us, and look, he's trying to help the Naxalites. He has to be a Naxalite. Again, this was trying to set up a narrative. But anyway, the judge was superb. He went on the evidence, and the evidence was principally enabled by the fact that the lawyers from JAGLAG had collected the information on the basis of which we were able to cross-examine the witnesses. And we were able to establish our case. Now, what did the evidence show? The evidence showed that though the leader of this police party, a DIG, the CRPF, and all his witnesses claimed that they were fired upon and that they fired in self-defense in order to save their lives. The DIG himself, who was leading the party, was at the very forefront of the party, and who faced the maximum number of bullets according to him, did not fire a single shot. He didn't want to get his hands dirty. Didn't want blood on his hands. Similarly, what became very clear is that most of the firing was done by very few people. Most of the soldiers had not fired at all, which again belies their claim that they were under fire from both sides of the road. The injuries on the deceased, there were 17 people killed, including a 14-year-old boy and many of 2-3 women. The injuries were gunshot injuries at almost execution-style killings. So, for example, they were on the head, and they were with the upward to downward trajectory. A lot of the shots were on the back.
Okay, sir.
Henry, will you mute your mic, please? Anyway, many of the people were shot on the back, others were shot on the head, which again belies their claim that they were, and it was pinpoint accuracy. That these people were the aggressors. Now, at the end of it, the Commissioner of Inquiry gave its report. This report came out 2 or 3 years ago. What has been done since? Nothing. What can be done now? This is now almost 10 years since the incident, maybe more. What can we possibly do? Can we have a trial? Can we bring these people to justice? The Commissioner of Inquiry report has clearly held there were no Naxalites. The Commissioner of Inquiry report has held there was no provocation. The CRPF fired on unarmed villagers. There were no Naxalites present there. What can we do now? But nevertheless, this report, like Mangla's report, stands testimony to what has happened. Bringing to justice is an incredibly difficult thing. But what we have learned now is that even if you were to do a trial or a private prosecution, what you need to do are these two things. You need to wrest control of the narrative at a very early stage, put out a counter narrative, and gather as much information as possible before you launch. And then that enables the launching of some kind of prosecution, of some kind of litigation. But let me not, mislead you. The odds are overwhelmingly against us. Jaglag was an exceptionally brave outfit. Lakhan Bhaiya's brother was a lawyer, a trained lawyer. He knew what had to be done and he did it. In most cases, by the time the lawyers enter the picture, it's too late. Evidence has already been destroyed. I have nothing more to add to this. This is what I have learned. I thought I'll put it before you. Thank you very much.
Thank you so much, Dr. Chaudhary, for sharing those thoughts and for pointing the possibilities and also the pitfalls of what lies before us. Thank you so much. We will open the house for discussion now, but before that, we have with us Henry Tefane, who's been quite dogged, campaigner on encounter killings as well. So since he's present, I would request him to, quickly share his thoughts with us, maybe for 3 or 4 minutes, please. Henry, are you there? Can't see you. Yes, Henry, please unmute yourself. And
I'm sorry. I suddenly unmuted myself at a time when I was doing something else. Extremely sorry. Let me congratulate Nalsar for this initiative and Mangla and team for this wonderful work that they have undertaken. At times of there being no hope, I think it is these reports that are being referred to by the speakers and in this case, Mangla and her team, which give us hope that the work that we do in terms of extrajudicial killings matter. But what is most worrying here really is that Mangla's report points out that it is the NHRC as well, which also contributes to such closure of cases in extrajudicial killings. One, that is clearly proved. And it is after 3 years that they have closed these 12 cases, in spite of people of the status of Mr. Wajahat Habibullah, Maya Darwala and others who have been a party to the correspondence with the NHRC, besides people like us. I think it is time this country asks the apex human rights body certain questions to be answered. In the 20 Tamils case that took place in Chittoor, in the Cheshachalam forest, the NHRC intervened after a lot of work was done, once again, as Justice Madan Nokur pointed out, by civil society organizations, and went to the NHRC with eyewitnesses, 3 eyewitnesses. Protecting those 3 eyewitnesses itself was a tough task for us. The NHRC, interestingly, within 7 weeks, passed a variety of orders, which I don't want to repeat here. The same were stayed by the Andhra Pradesh High Court in 2015, June. The killings took place on 7th of April, 2015. Till 1 week ago, the case was not heard and the NHRC did not possess the capacity to vacate a stay against its own order, ordered by the AP High Court. Now, we can continue. In not a single case of encounter which the NHRC has inquired, have we found that they have found something out and recommended not only compensation, but also prosecution of those responsible. So I think on an occasion like this, when we are with experts who have passed their own comments on the report and on the situation of encounter killings, that we call for a white paper from the NHRC on the encounter deaths that they have inquired and what they have done in return. Is it ordering compensation or have they ordered prosecution? I think this is extremely important that we do this, and it is time we ask for the UN Special Rapporteur on extrajudicial killings to visit India, because that is what is called for and that is what will shake the administration here. These reports are important. but these reports today are going to have repercussions. Repercussions on a variety of people, but all of us will stand together, because it is such reports alone which is going to tell institutions which need to work that they need to do their work much better. Thank you, and congratulations to NALSAR for, as an academic institution, for taking up this work so efficiently. Thank you.
Thank you, Henry. I remember when the UN Rapporteur for Extrajudicial Killings first came to India after having been fobbed off for years. Every time there was a visit due, the Indian government would fob it off. So finally, when they came to India, I think it was in the 2000s sometime. And the NHRC, if you look at the submission that the NHRC made to the UN Rapporteur, you would think it was the Home Ministry submission and not a NHRC submission. They said that, oh, we don't have a problem of encounter killings. It's only some terrorists, some insurgents, some criminals, somebody trying to, So I mean, you really look at it and think, is this the NHRC? Is this who we are entrusting with our, protecting our civil liberties? So now I think we will go on to the questions, because there are some questions, and a couple of questions pertain to what is, very commonsensical understanding of encounter killings, or commonsensical defense of encounter killings, that the process of, justice is so slow. And so people are impatient with that slow process. And so, and so therefore they celebrate these encounter killings. So if Justice Lokur or you would like to respond to that, very commonsensical and, sort of refrain that we hear all the time, that, oh, the wheels of justice grind too slowly. And so, what choice is there? Except for vigilantism.
Yes, Manisha, there is no doubt. There is no doubt that the process of justice is very slow. And something has to be done about it. I mean, I gave you some of the figures of, what's been happening, how many, cases of bail are pending, accused absconding, witnesses not being present. Today, we have something like 2.95 crore. That's 29 lakh cases. No, sorry, 2.95. There's about 290 lakh cases pending in the trial courts. Criminal cases, I'm not talking about civil cases, criminal cases. They constitute 60% of the bulk of cases that are pending. How are we ever going to go through them? I just don't see any solution unless somebody says that, listen, we got to do something. Now, in a situation like this, the people are going to get fed up, and people are going to say, well, I'm going to take the law into my own hands. And then you have a bigger problem. If you have people taking the law into their own hands, how are we going to tackle the situation? But none of this, let me be absolutely clear about it, none of this is a justification for encounter killings. None of this is a justification for people being picked up and disappearance. It's not a justification. But we have to wake up. I mean, somebody has to wake up and say that, listen, we've now got to do something about it. I think it might be too late. We've reached a very, very critical point. And there doesn't seem to be any improvement. So really the discussion has to be a much broader, wider discussion on where do we go from here? What is the status of human rights in the country? Can you keep people in custody without producing them before the magistrate for more than 24 hours? We saw that happening on television a few weeks ago. We read in the newspapers about 700 people being arrested in one state. What are we doing about it? Silent spectators. Who is to do all this? Everybody has to do it. The judiciary has to do it. The government has to do it. But I don't know. It's just frightening. That's all that I could say.
I could just supplement what Justice Lopur has said. I think certainly the state of the criminal justice system, the pendency of cases may well be a contributing factor to the incidence of encounter killings in India. But it is my firm belief that the nature of a state is such, the nature of state as an institution is such, that when threatened, it responds with lethal violence. This is true of the UK. It is true of the US, which has got much lower pendency than us. But we have seen encounter killings even in the UK and in the US in vital cases. And let me give you one case of the UK. Not too long ago, the Justice Hutton inquiry was looking into whether or not the British government had lied to Parliament about the existence of weapons of mass destruction. A leading scientist, Professor Kelly, was to give his deposition on a particular day in the morning. And on the very day that he was to give his deposition, he was found dead, lying in a field somewhere. These kind of things, we have seen this kind of thing happening in America. We have seen it happening in different parts of the world, in Russia. Whenever the state is threatened, it responds with lethal violence. Now, the question, so it's the nature of the state. It's nothing, you may educate people as much as you like, you may spread liberal values, but the nature of the state is such, and this is regardless of whether it is a right-wing state or a left-wing state. It is the nature of the state to respond with lethal violence when it is threatened. The only way to protect is to build up institutions which will act as checks on the state. I think that is the only defense that we have.
Thank you. And if I may just add, sometimes I think this plea of, the criminal justice system not moving fast enough, I think is sometimes a poor defense, because it's not every rape, every murder that excites us. There's no public approval or celebration or demands for instant or vigilante justice in every single case. We're not, as much exercised about, women being raped in the Northeast as in the Manorama killing. Rape and killing of Manorama, or in Kashmir or elsewhere, right? So it's a specific kind. So it's in terms of public approval for or defense of encounter killings. It's also what I was saying earlier, that there are certain categories of encountrables which are seen as people who are expendable, and so therefore they can be bumped off in encounter killings. So and there is a great deal of approval for that kind of those kinds of killings. Now, so there are questions. I think partly you guys answered it by saying, that we need to build up institutions, but there are a few questions about what kind of solutions can we think of? Is there reform in criminal law? Do we need to have a law on accountability? What are the possible sort of avenues open for us in terms of, what can we think of? Not that anybody is listening to us. But what are the possible things that one could push for?
Manisha, if I can just add into that question that I wanted to ask.
Yes,
just that we talk about police reforms, we talk about that bit of the criminal justice system. What about the judicial magistrates? Because they are a very key element of the criminal justice system. They are the first line of defense. So a lot of things, in our research, we figured that, a lot of things could have been stopped had the judicial magistrate taken a stand, looked at evidence, done all of that. So while we talk about police reforms as one thing, I think that is one aspect also of, training, of, I don't know what would be required, but I feel that's a missing sort of link in all of this.
Also needs detoxing, I think. So prejudices that we're all afflicted by. Okay. So would any of you like to respond as to what can be done? I think partly you guys responded.
Yeah, well, I think the stage of reforms is over. We need an overhaul, right? Reforms are a few things, but the entire justice system needs an overhaul. Okay. I fully endorse the view of Mohit that the institutions need to be strengthened. Which are the institutions? The judiciary, the police, the prosecution. The prosecution has to oppose everything. If somebody has got Parkinson's and he wants a straw so that he can drink water, it has to be opposed. Why? If somebody wants something else, it has to be opposed. Why? How do you change this? You know, so it needs a complete overhaul. It needs an understanding that there are something called human rights, which we all have. It's not only the prosecutors or the police that have human rights, it's also citizens who have human rights. And unless that message is sent across, we mentioned about strengthening the judiciary, strengthening the NHRC, state human rights commissions, police accountability commissions, you name it. Unless they're strengthened, unless they realize their responsibilities under the Constitution of India, this thing will go on, There will be more and more encounter killings. One state was bad enough, now another state says, okay, we are also going to do the same thing. So you have two states. And the third one will say, what about us? Yeah? Let's also indulge in encounter killings. And then what happens? So you have 3 states, 4 states, 5 states, encounter killings everywhere. Yeah, this has to stop somewhere. And it has to stop now. And, a report like this should be disseminated. I mean, it's not to be kept in a library or something. It has to be disseminated to everybody. Police, legislators, civil society. Tell them this is what's going on. Are you going to tolerate this? If the answer is yes, well, I don't know what to say.
What would be your view on a law on accountability, sir? Do you think?
Accountability, yeah, it's absolutely important. It's absolutely important. Otherwise, you have this culture of impunity, which is what Armed Forces Special Powers Act was trying to do. And the Naga People's Movement and the Manipur case, we said, you don't have impunity. You just can't pick up a person and say, all right, whatever we want. I'll share one experience that I had in Manipur. I was told that there's a particular person who has some wonderful sculptures that he makes from the roots of trees, and that I should go and visit his studio. I requested the registrar to talk to him and see when it's convenient for him for me to go and meet him. And the registrar told me, he said, listen, I don't think he'll allow you to come. I said, why won't he allow me to come? He said, because he has a hang-up with the state. He doesn't want anybody from the state to enter his studio. I told the registrar, I said, please tell him that, I don't represent the state. I mean, in that sense, I represent the judiciary. And unless he has a problem with the judiciary, well, I'd like to know what his problem is. So the registrar spoke to him and he allowed me to come. Excellent sculptures. But I asked the registrar, I said, why does he have this hang up against the state? And he said that one morning at about 3 o'clock or 4 o'clock or something, 2 insurgents came to this person's house. The 2 insurgents were armed. And they said the police is behind us, they're trying to catch us and, give us a hiding place for a couple of hours. He had no option. He had to put them, in some safe place in the house. The police came, they looked around, couldn't find him, they left. Later on, they realized that he was in this person's house. He was arrested under the National Security Act for harboring insurgents. And he was in jail for 9 months before he was released. So, you have these kind of things happening to perfectly innocent people. So a couple of things here or there, won't make a difference. You have to have the police accountable. And as Mohit said that this case of Lakhan Bhai was the last. Why was it the last? It was the last, perhaps, I don't know, because the persons were convicted. If they hadn't been convicted, well, these encounter killings may have continued. So yeah, accountability, absolutely important. Witness protection, absolutely important.
I think we're running out of time now. There are still a couple of questions, but perhaps we'll have to let go now because Justice Lokur has to go at 7 as well. So I thank all of you, especially Justice Lokur and Dr. Mohit Chaudhary, and of course Mangala and her team, and above all, I think LiveLaw, who's been very, very generous in supporting this program today and broadcasting it live. Thank you all for supporting this event, supporting this symposium, and agreeing to speak here, both of you, sir, Justice Lokur and Dr. Chaudhary. And congratulations once again to Mangala and all her team for bringing to us this very excellent report. And I hope that the link to the report is given in the chat box for everybody. So please do download the report, do read it. And I think, as Justice Lokur said, it's everybody's business. It can't be, the job of few civil liberties activists or those who've been touched by this, encounter killing. But I think it's everybody who thinks or believes in the rule of law, who believes in the sanctity of Article 21. And also, I think none of us are safe, really. You tend to think that, okay, it will happen to somebody else. But the list of encountrables is never static. It keeps on expanding. Yesterday, it was the terrorists. Then today, we have the criminals and the rape accused. Tomorrow, it can be protesting farmers. It can practically include everybody and consume all of us. So I think we are all invested in this, and we should make it our business, as Dr. Chaudhary says, of strengthening our institutions, which will curtail the power and the might of the state. Thank you all for joining me today. Thank you, LiveLaw, as well. So we shall now end the program here. And apologies to those whose questions we couldn't take. I'm so sorry.
Yeah, thank you and all the best.
Thank you, sir.